Hi, my name's Kent, and I live in Meriden, Kansas. I wasn't born in Kansas, but I married a Kansas girl, and 21 years ago, Debbie and I moved to a small Kansas town very much like so many other small towns across our state. Everything in my town is literally within a few blocks of everything else. City Hall and the post office are only a few blocks from the elementary school where my wife teaches. A few blocks further down the road is the middle school, and just behind that, the high school. No small town is perfect, but this has sure been a great place to raise our 3 children and to build relationships with some really great people. Our kids have grown up making lifetime friendships, and we've enjoyed it all more than we ever imagined possible. But the simplicity and sanctity of our small town is being severely threatened, because in our small town, on property adjoining school property and just outside the city limits, a businessman from another county bought a building, and before he ever had all the necessary permits, expanded and improved it, investing, he now claims, over $300,000 in order to open a gentleman's club. Now, Jefferson County doesn't have any sexually oriented businesses currently operating, but there is a process in our county that requires conditional use permits in the case of a club like this one, and only after buying property and investing in improvements did the club owner apply for the required conditional use permit. But because of traffic concerns related to his location, proximity to the schools, the adverse secondary effects associated with sexually oriented businesses, the permit was unanimously denied by the county commissioners. Now he's suing the county. In a lawsuit his lawyers promise will cost our county hundreds of thousands of dollars to defend, claiming in his lawsuit that his free speech rights, his rights to put naked women on display for profit, are being violated. Jefferson County has zoning regulations and a process in place to ensure those regulations are followed. The system worked, but because the result was not to the businessman's satisfaction, it's still going to cost our county significant taxpayer money to defend legal actions legally taken. And our story is not new. It's been told before, and it will be told again unless the Kansas State Legislature chooses to act, and act now. The Kansas Legislature returns to work for a 4-day veto session on April 27, 2011. This brief session presents the last window of opportunity to see the Community Defense Act, Senate Bill 25, become law in 2011. The Community Defense Act will provide uniform regulation of sexually oriented businesses, helping to enforce the will of the people, not just in my county, but uniformly across the state of Kansas. Without this legislation, counties and communities across Kansas remain vulnerable to the same sort of heavy-handed business practices foisted upon our small town, and to the same sort of outrageously expensive to defend lawsuits like the one filed against Jefferson County. I am asking you to stand with other like-minded Kansans from across the state by insisting that our elected representatives provide sane regulation of sexually oriented businesses. Today, please contact your legislators, both House and Senate, along with Speaker of the House Mike O'Neill and Senate President Steve Morris. Let them know we want all Kansas communities protected through immediate passage, 2011 passage of Senate Bill 25, the Community Defense Act. For more information, visit the website of the Jefferson County Citizens Group at www.jccg.info. www.jccg.info.